Writ petition is dismissed. Right. Yes.
Item number 3.
Item number 3, yes.
I have done this matter only for the
On behalf of whom?
our own Lord.
Inform the other side.
Yes, Lord.
Okay. Okay. On a request made on behalf of the petitioner. Pleadings are complete, Mr. On a request made on behalf of the petitioner, matter is adjourned by 2 weeks. Yes.
Hello.
Tell us. List on request. List on 28 28.
Right.
Right, sorry, huh?
Right.
28/7. The 2 weeks will matter is adjourned. Matter is adjourned by 2 weeks. Matter is adjourned. Huh? For 2 weeks, matter is adjourned. Full stop. On request, list on 20.
Meet this challenge.
Just a minute.
Very limited prayer, your lord. I had 3 katas of land, and I
Just a minute. Just a minute. Just a minute. Just a minute.
had 3 katas of land.
Not by this. Before any other bench.
Highly obliged.
Please before any other bench.
Item 13, copy list.
It might
Yes, yes.
matter adjourned for the time being.
Time being today.
Yes, after thought by.
Stay vacating.
Yes, my.
You have applied for vacating of stay.
No, my.
You are the writ petitioner. Opposite party. You have applied.
For responsible person.
And
I have filed I have for and also the PWD. has also-
okay, the matter which was listed before
Yes,
yesterday.
yes.
Yes, where is Mr. Nath? Is he there? He is also not there. Who? Mr. Roy Chaudhary is a
Yes,
senior.
my.
Okay.
He's now in the 13 other.
Then after a while,
Yeah.
Mr. Nath will appear, Mr. Sharma. Please call him because we cannot keep on adjourning matters.
Item 14,
Better make IT for typing.
Yes,
Can
Mr. Sharma, there is an interim order.
Yes.
We are not on the merits.
Yes, Lord. I have
The
seen Lord.
that perception is a thing, is within your domain. You can take a decision. If it
That
is a fresh
decision-
decision, we can tell we might not have even thought about in granting an interim order. It's your prerogative.
Right.
No one can say that. But there is an interim order in the writ petition.
Yes, Lord. That I appreciate.
Only for that reason
Otherwise,
we are.
Lordship, they have a very bad case, Lordship. Otherwise, but as because there is an interim order. Lord.
Get the interim order vacated, get the main writ petition
Not-
disposed of, dismissed. But that way, we have even seen that the interim order which was passed on the initial date, it is not a case that it was not extended. It was extended on every occasion.
Yes.
Lord.
So as on today, there was an interim order.
Lord.
So before you make an exercise, take leave.
Lord.
Mr. Chaudhary is otherwise there in the
Yes,
court.
he is on.
Okay, we'll say he's there because he was there yesterday.
Yes.
Part 3, K.N. Chaudhary, London Senior Counsel, assisted by Sri R.M. Deka, for the
Okay.
applicant, who by means of this application has prayed for stay of a communication under memo number Sailob, dated 15/7 memo to Diba, issued by so-and-so, Gutekhin. It is the case of the petitioner that the issue regarding removal of PSO is pending in the connected writ petition WPC 1873 of 2024, in which an interim order has been passed and is continuing. Full stop. However, by disregarding the said position, the impugned communication has been passed. Full stop para. 3H Sharma, learned additional senior government advocate has very fairly submitted that the communication appears to have been passed after an independent exercise on the aspect of threat perception, in which the aspect of the continuation of the interim order might have escaped the notice of the authorities. Para. While this court will not like to make any observation on the requirement or otherwise of a PSO for the petition, for the applicant slash writ petitioner at this stage, this court is of the opinion that when there is an interim order passed by this court in the connected writ petition, which is continuing, the present the impugn communication should not have been issued without taking leave of the court or without the interim order being vacated. Para. In view of the above, the communication dated 15/5/2025 shall remain suspended till the suspended. Full stop. The issue regarding the requirement of PSO would be decided in the connected writ petition. I stands disposed of.
In the writ petition, Lordship, may I make a prayer, Lord? Let
Yes.
it be fixed for a final disposal, Lord.
The writ petition may be listed for admission hearing after 2 weeks.
Interim order in that which petition will be
That
continued.
we have already said.
Lordship, may I pray that if it's not it continues? It as per your
2 weeks we have said.
Lord.
Job like.
Item two,
May please, Lord.
Yes.
As per the last order, my Lord,
Yes.
government submitted a request from instruction regarding the settlement of land on the petitioner. We have already applied, my Lord, the case is pending.
Yes, Mr. Sharma.
Lordship, I am extremely sorry, Lordship, most probably we have inadvertently, Lordship, no letter is sent from our side.
Where is the land?
And is it Peltolam? Lordship will find our application at 45C, my Lord, that is the application for settlement, my Lord.
No, you have to take a decision, Mr. Sharma, either to allot or not to allot.
Lord,
He has applied for allotment. He cannot as a matter of right, but right of consideration is definitely there. When can you come up?
it is after, let's get that check.
What is the status? What is the present status of the land now?
Status, right now the petitioner is under position of the land because of the interim order granted by this honorable court, my Lord. Prior to the settlement of land, my Lord, an eviction notice was issued, my Lord.
That we see, that we have seen.
Yes, that, we have challenged that notice, my Lord, in this petition, and also that
Oh.
on disposal of our application.
H. Sharma, learned additional senior government advocate, prays for some more time. Para. The petition being of the year 2018, as an exceptional circumstances, a final opportunity of 2 weeks is granted to enable him to obtain instructions. Para. List after 2 weeks for admission hearing. Interim order, if any, stands extended till the next date of listing.
I'm deeply aware.
Lordship, most probably I need a copy of that, because our
Okay,
copy.
give
is
a copy.
complete, Lord. Sorry, thank you. Sorry.
Obliged.
4 and 5 for hearing.
Sometime, Lord, permit.
After some time means who will come? Saikya,
My Lord, coming.
please call him. All
Yes,
matters,
yes.
we don't have much matters today.
Yes, yes, ma'am. I will promise.
Yes. After a while.
Oblige.
6 and 7.
Passes matter that
Why all matters time being? What will we do?
is in legs,
Hmm?
in legs or
We pass over for the time being, but second round we're not going to pass over, okay, for the time being.
Item 8.
Yes,
I am appearing on behalf of Mr. P.K. Sharma. He is unwell, my lord. Could not be present.
Mr. Sharma, what is this?
Lordship, matter bit two, some prepayment charges and the foreclosure charges.
Year for whom?
I am for the expected. Your lord.
Matter is pending since 16.
Yes, sir.
What is the stage now?
Your lordship, proceedings has already been completed.
No, stage of the proceedings, not the case.
No, there is no proceeding, your lordship. My account has been closed and I have recovered the amount, prepayment charges and others. Now their allegation is that prepayment charges imposition is illegal.
No, so he's not well, otherwise we would not have adjourned the matter.
Yes, sir.
Okay,
And
on
it will
first,
come up after, on a next
okay, it is submitted, that's Sri P.K. Sharma.
petition. ma'am.
Learned counsel for the petitioner is unwell. Also heard Sri M. Sharma, learned counsel for the respondent bank para. Considering the personal difficulty, the matter is adjourned to be listed when? To be listed on, today is 17th, listed on 29th, Tuesday,
Your lordship, month end is there, lord. Just pay.
on 24th. 24th, next Thursday.
Let it be the first week
Why are you postponing matters like this?
of postponing, your lordship.
On 5th of August. 5/8.
Right.
Yes, Mr. Saikya.
So there's two petition methods. Let's take up the WPC number 1259. Item 4.
Pachaji for whom?
Have to repeat.
Revenue, okay. Is there any private respondent? No.
No.
What is the matter about?
Well, matter is not all these
Mr.
petitioners.
Saikya, you want which matter to be taken up first?
Item number 4.
4 is
One-
1259.
Five.
Okay. Mm.
All these petitioners, whether they are the owners of the Blick Clean.
How many petitioners are there?
There are four
4 petitioners.
members.
Yes.
They are the owners of the Blick Clean Melod, which are established in the private land. Private owned patal.
In their private land, in their patta land.
India. Now, so far as this establishment of Brick Clean, etc., there is no rule as such initially.
Okay.
So, since the year 1984, the government have issued a notification for regulating the establishment of the Brick Clean.
Notification is dated what?
Dated 31/3/1984. Lordship will find at page 20.
Yes.
May I read it?
Page 20.
Page 20. I am directed to say that it has come to the notice of the government that there has been rapid growth of the brick industry in the state, and many of the industrial units are using land from government PCR, VCR, and government fast land without valid permission from competent authority. The matter of realization of royalty and laying down terms and conditions for granting lease of land for manufacturing Brick Clean has also been engaging attention of the government since long time past. Government, after careful consideration of all aspects, have now decided to lay down a policy for granting lease of manufacturing brick clean tiles on the government land only for 3 years to private individuals, cooperative societies on realization of royalty at a rate of rupees 2.50 paisa per cubic meter on brick art on the following terms and conditions. The period of lease shall be 3 years only. The surface rent for the area should be paid in such that
Now, this is for government leasing out.
government
You said
leasing
that
out.
your brick clean is in your own pata land.
Lordship, ma'am.
Okay.
In my own patalat, thereafter various notification on the same line have been issued. Then
Yes.
ultimately what they have done, they started realizing the royalty in the nature of a fixed amount of rupees. Initially it was 10,000
Per?
per brick clean
No, 10,000 per month or per year?
per year on the brick art used in the brick clean. Not on the brick clean, but on the brick art used in the brick clean.
Yes.
Now, so far as this brick art is a minor mineral, so initially that under 1957 Act, so it is leviable, but no rules were framed. In 2003, that some minor concession rules that has come, but under that, brick art was specifically mentioned as a minor mineral. So the government has the power to levy royalty or the issuance of property tax. But they have not realized that the revenue department, rather, it is the forest department who is under the minor mineral concession rule can realize, but they have not realized. Rather, the revenue department, by way of this, they have been realizing. So since the royalty has to be paid under this act or the other act, we did not object to that, so we had been paying. Now that suddenly that amount has been enhanced to 25,000, and then we have approached this the Brick Clean Association, they have approached this honorable court, challenging that imposition of 25,000 as a royalty. But
That has been increased to 25,000.
25,000. Then initially there is an interim order for to pay at a reduced price of 7,000, but subsequently on the
So why 7,000? It was 10,000.
7,000 as an interim order.
No, why even 10 was reduced to 7. You were paying 10 already.
Sorry, 10,000 instead of 25,000
The earlier,
earlier.
means it was stayed rather. The announcement was stayed and you were
Will
directed
continue
to
to
pay
pay
in the earlier rate.
Earlier rate.
Okay.
Then subsequently government also found the various aspects of the matter, and to weigh out the whole situation, there was a compromise with the government has relaxed the things, and they have said, all right, henceforth will be realizing at the rate of rupees 12,000.
Reduced to 12,000.
12,000. So matter was disposed of uncompromised.
The earlier writ petitions were there.
There was that challenge to the 25 position of 25.
This is not the 25 challenge.
No.
Okay. The other, there were other writ
There are
petitions.
at page 29 that order I have annexed.
And those writ petitions were disposed of. Okay.
And thereafter we had been paying it this rate, my lord.
12,000.
10,000.
No, not 10. 12. It was agreed on 12, you said.
Agreed on 10, my lord, at page 29.
No, then there was no agreement. They had withdrawn the announcement.
My lord, the respondents have filed an affidavit dated so and so. In the affidavit, the respondent have stated that association of which the petitioner is a member is agreed to pay rupees 10,000.
That
Per
means
year
they had
royalty-
withdrawn rather.
Yes,
The earlier was continued. Maybe
10,000
after a
continued.
discussion, but there was no
Exactly.
change with the amount. It continued as 10,000.
Lord.
Correct? Okay.
Lord.
Not 12,000.
Lordship.
No.
Now we have been paying that amount. While continuing, my lord, that amount, my lord, the Ministry of the Government of India, Ministry of Environment and Forest issued guideline for grant of the environmental clearance from mining of brick art and ordinary state to the state environment impact assessment authority.
Yes.
That we have to obtain, my lord, this environment clearance certificate.
Hmm.
That is, my lord, and accordingly we have obtained, my lord, page 39 Lordship may kindly come, my lord. This is the guideline.
Yes.
Pursuant to that, my lord, we have all applied, my lord. And page 43,
You obtained a certificate?
certificate.
Okay.
And one of the clause here, your lordship will find page 45,
Yes.
the project proponent shall comply the provision framed under Assam Minor Mineral Concession Rule 2013
Yes.
at page 45, seal number 3. Then clause 10, the project proponent shall deposit royalty as by existing Assam Mines and Mineral Concession Rule 2013. So this
Yes.
is one of the condition, my lord, for accepting, notwithstanding this, my lord, this certificate, we have to pay the royalty under the Assam Mines and Mineral, Concession, my lord. And accordingly, we have paid, my lord.
Now, what is your grievance?
My lord, what happened now? Now we are paying the royalty to the government
Hmm.
through the mines and minerals now. That is the present status.
Hmm.
Now, then, my lord, they have again, the department has, the revenue department has directed that we have to obtain a NOC. And for the purpose of NOC, we have to continue the payment of rupees 10,000 what we have been paying, my lord, under that act. So this demand of NOC has been challenged in the other writ petition. And thereafter, my lord, this writ petition has been challenged, that they have again, my lord, they have imposed rupees 10,000 per year. Under the
10,000 you,
NOC.
10,000 you are paying already. What is the grievance?
No, that was, my lord, why we had paid. Because though the royalty was payable under the Mines and Mineral Concession rules, they have been realizing revenue department. And since we have to pay the royalty, whether under this act or that act, we
No,
did
that
not-
you were paying.
we
That
ca-
was increased to 25.
Lord,
You made a challenge. Matter was compromised. They
Right.
withdrew the
Right.
announcement.
Right.
You kept on paying at 10,000.
10,000.
Now, why is the
Then
now
under this environment assessment,
that you have that has been cleared? You have
Cleared.
got the certificate.
so for that we have to pay the royalty.
Forest royalty.
Forest
How
royalty.
much?
My lord, it is, my lord, much more, my lord, will find, my lord, these royalties are page 55. The certificate we have obtained. These are the series, my lord.
Are you paying forest royalty?
Yes, yes.
How much?
My lord, these are the, my lord, page 55
Now
onwards.
give
my
us an amount.
lord. 30,000. Then, my lord,
30,000 per year, per month.
per year. Per, my lord, this is,
I think this is a one-time payment. Who is appearing for
2,000
forest? Who is appearing for forest department? Is forest a
this
party?
30,000 is for 2,000.
Forest is a party, Mr. Saikya?
Yes,
Forest is a party?
yes.
Who is for the forest?
Forest
Mr.
Depart-
Das, please inform anyone from forest department.
Now, forest department has not filed any affidavit. They did not file.
No, we want to have who's appearing.
Good.
Madam Mahanta, please inform.
So this is, my lord, per cubic meter. This rate has been fixed per cubic meter. This annexure 50, page 55 would show, my lord.
Hmm.
The royalty of rupees 30,000 and 37,000 on account of 25% of the annual royalty amount sale tax of so and so, so and so, so and so. So the pre-clean, the royalty is at the rate of, my lord, the per cubic meter. Now, my lord, this revenue department now then, my lord, will find at page 67. Our case is that the revenue department doesn't have any kind of power and jurisdiction. In fact, they don't have any authority to levy royalty on brick art.
Mr. Gogoi?
This matter, if I can recall properly, they are agreed by cess, which was not imposed by us. It is imposed by the revenue. We have, as a forest, we have no role. Otherwise,
No, your rule will come in because they are trying to make out a case that they are paying forest royalty. After the environment clearance certificate
Correct.
requirement was introduced, they have got the certificate and pursuant thereto, they are paying forest royalty, which has been calculated on a per cubic meter basis.
yes,
And they contend that initially, though there was a demand and also payment of rupees 10,000 by the revenue department, they were under the impression that it should have been by the forest, nonetheless by the revenue. So keep on paying. There was an increase, writ petition, then demand was it was withdrawn, writ petitions closed. Now forest royalty they are paying. Now when they are paying forest royalty, they contend that the revenue would not have any jurisdiction to impose a further royalty of rupees 10,000.
but then revenue has to justify why.
Now revenue will be there,
Yes.
but
Otherwise,
your why your role will be there. You'll have to say that whether payment of forest royalty will absolve the party from any other payment of any other cess or levy.
otherwise, brick art is a minor mineral.
No, the second immediately the question will come that the area in question is not forest area. They are
Private
private, it's patta land, according to what Mr. Saikia has said, and we have accepted. We have not verified, but what he has said, let us go by the face value. It's on his patta land. So even patta land minor mineral he has to pay. That he is paying. Now whether the revenue will also have a jurisdiction to impose anything.
My lord. To look into my.
Yes, Mr. Bhattacharjee. But you be around, Mr. Gogoi. Your
Well,
role will be
okay.
there. We'll come back to you, Mr. Saikia. Let us have a preliminary thing of what Mr. Bhattacharjee is.
substantive written outment also by way of an additional affidavit.
We have filed
Written argument or additional affidavit.
one additional affidavit plus another written out. Both these things will cover.
Okay. What is
Well,
your case?
In the absence of any state to the effect, the state has the power under executive instructions that has the executive power under Article 160. Now, industry, since Big Clean is an industry, it comes under entry 24 Schedule 7. This
Yes.
So accordingly, we have been doing circulars from 1984 onwards on the subject of brick laying.
Yes.
And in my additional affidavit,
Just a minute, please. Entry 24.
yes,
Industries subject to the provisions of
yes,
entry 7 and 52 of list 1. Industries.
yes,
It's a state subject.
it's up.
Now you can make laws.
Yes.
There is no
See-
law.
There is no law, but this executive instructions will hold up.
Now, why have you introduced the executive instructions? To
Because the-
supplement or to supplant?
My lord.
Have you introduced it to supplement something or supplant? There is nothing to supplement, there is no law. So why is the need?
Need,
You,
my-
your power, your jurisdiction
Fine.
to make a law on a subject which is under list 2,
yes,
that is not in doubt. That is the constitutional mandate. But
Ye-
there is no law.
no law.
In absence of a law, executive instructions in pursuance to which law? In connection with which law?
My lord,
These lists are only for enabling you to make laws.
since Bricklin, yes, the written act, since Bricklin is an industry in terms of section 25B of Assam Land Revenue Reassessment Amendment Act 1997, read with section 2H of Assam Agricultural Land Regulation of Reclassification and Transfer for Non-Agricultural Purposes Act 2015. These two
Which are the acts?
first is Assam Land Revenue Reassessment Amendment Act 1997,
Which section?
section 25D.
Twenty? Special provisions in respect of industrial site.
Yes,
What is this? Please read.
I just thought I'm trying to find out.
Is there anything important? Then settled at the right of renewal.
Special provision in respect of industrial site. Notwithstanding anything contained in section 18 or any other law for the time being in force, the state of Assam, the rate of revenue for land settled with right of renewal and class as the industrial site shall be assessed as 10%.
Oh, you relate your power to this provision of
Yes,
the act. There is a statutory provision.
Yes.
Okay. And you are trying to supplement the statute by the means of this
Executive.
executive instructions.
Now, in the
Let us see the executive instruction.
Yes.
Is it in consonance with the rules?
Yes.
Or is it supplanting the rule?
Revenue, land revenue for the industrial site apart from.
Now, let us see
instead-
the impugned, they
Instead
have,
of normal land revenue, if it is an industry, in that case, industrial site, it will be assessed by 10% or whatever percentage,
Hmm.
enhanced at that.
Hmm,
That is the purport of 25.
yes.
gradually.
Not
is-
for royalty, royalty is altogether my lord, different concept, my lord, as your lord.
Now, what is the expression used in the impugned order?
Royalty.
Well, in
We are realizing, the revenue has been realizing as per 25P. That land revenue we are paying at the enhanced rate as per the 25.
that
that is
was
separate.
changed in 2001.
Huh?
That was changed in 2000.
What was
Well,
changed?
I come. Page 97 is the first circular issued in this book. Connector A of my affidavit in Oput,
97.
97. This is first in point of time. Affidavit in-
No, that Mr. Saikya has already read out.
Yes.
84.
This is 84.
Yes.
Then, my lord. Next one is my 124 my of my additional assets.
124.
1 to this is issued in 1986.
7 January.
7 January. Some brick lanes have been set up on land which are suitable for agricultural purpose. Considering the importance of agricultural land, the government have decided that no government land suitable for agricultural purposes will henceforward be allowed for setting up brick lanes.
Hmm.
This is the next development.
Yes.
Then in 2001, there's another one in 1986. This is 26th of May, 86. It's 126. This is 126. Same affidavit.
May.
26th of May.
What is this?
It says that it has come to the notice of the government that many people have set up brick industry on their own patta land and on Sarkari or reserve land. Since bricklaying is an industry, apart from royalty at the rate of rupees 2.5 per cubic meter, then revenue at the rate of 10 times of the highest rate classes of land in the village, that is Halbari, should be assessed. So this is for the first time it is said that apart from land revenue at 10 times of the class of land, it has to pay royalty.
No, apart from royalty.
Apart from royalty, he has to pay land revenue.
Yes.
So this is the development in 1986. It's going in 2001, phase 127.
Yes.
Another notification 28th of November.
Yes.
It sums up many things. Man. That government have reviewed the instructions issued earlier in connection with the establishment of bricklaying state. The revised instructions now itself supersede earlier all. Royal. In addition to the land revenue to be assessed and realized as per Section 25B of Assam Land Revenue Reassessment Act read with Rule 16 frame thereunder, royalty for art use for the bricklanes shall be paid to the DC SDO civil in the commencement of the. So the difference between the royalty imposed by forest officials under Rule 26 of the Assam Minor Mineral Concession 2013 and the royalty imposed,
2013.
yes, it comes under
Yeah, right.
yes,
The
13,
rules were of 3, then amendment came in 13.
13.
Okay.
So there's the basic difference between this. Yeah, just get why the forest royalty is. If George may kindly have the Rule 26. Rule 20,
Rule?
20.
Twenty-six.
20. My book it is in page number 6.
No, we have. Permits.
Yes.
Permits for extraction, excavation.
Excavation of brick art by bricklaying.
Yes.
A permit for excavation of brick art may be granted by the competent authority in favor of the bricklane owner only for the purposes of manufacturing of bricks.
Yes.
Number 2, the initial permit shall be granted for a period that co-terminates with the close of the next financial year so that the further renewal thereof is allowed on biannual basis. Number 3, the excavation of brick art under this permit shall not be permissible beyond a depth of
9 feet measured from the natural ground level at the edge. The application for lifting of brick earth shall be made to the competent authority in form so and so along with the following purposes document. Number 5, the existing bricklane owner shall apply 90 days before the expiry of permit already held. In case of excavation of brick earth is to be carried out in the same area earlier held on permit, the bricklane owner shall apply for renewal of the permit 90 days before the expiry already held. Number 6 is important. The
Yes.
royalty on account of excavation of the brick earth. This I am emphasizing. This royalty they have to pay for excavation of brick earth, which they can get it from any other. And they can dig it out up to 90 as permissible under.
24 on account of excavation of brick art shall be charged. This is chargeable by the forest department.
Forest. And
This
why?
is for
Because this is the
use of the arts
earth
up
for
to
the
a
purpose of
production of bricks
yeah,
and up to a certain depth.
and they have to
It's-
pay.
By both, in case brick art is used for industrial purpose, in that case, director of mining and.
We'll come
yeah.
to you.
Now the basic difference between this and the royalty levied by the revenue department,
Hmm.
I have stated in paragraph 6 of my additional levy.
This
Page number 118.
no, this is the source of the demand or for payment of royalty by the forest department.
Yes.
This is the source.
Yes.
Now, so far as your demand for payment is concerned by the revenue department, so as the source. The second corollary question is the source questioned? See, your power has to be related to a source.
Source.
Now, if you can show a source,
Yeah.
the question will come that whether the source has been the subject matter of challenge or not. Perhaps the source is not the subject matter of challenge. So you have to show us the relations between the exercise of your powers and the source. If you can do that, I think your matter, you'll be discharging your burden.
Fine. So my source comes from the executive department. And
Which
2001.
Page,
Now the purpose
executive instructions of 84.
from
Which one?
84 onwards, from 86 and 2001. These two are just I have read.
120, 97, 124, 126, and 127.
Yes. These are my. And why we levy that I have stated paragraph. Page 118.
118.
100 in paragraph.
Paragraph 6.
Yeah.
Please read.
The royalty under the provisions of Assam Minor Mineral Concession Rule 2013 is levied for the use of brick earth in the bricklane industry, as the brick earth is a schedule item under Schedule Y appended to the SID. As against the same, the royalty collected by the Revenue and Disaster Management Department is collected for the use of and damage caused to the earth, surface of the earth, due to setting up and running the bricklane industry. Due to setting up of a bricklane, there is gradual loss of productivity of the land, making it unfit for agricultural purposes for years to come. This is the exact.
Yes.
There is judgment of the honorable.
The purposes are different.
It's
So
purpose
far
is-
as the forest is concerned, you are trying to contend that their royalty is on the use of the earth for production of the bricks. And your levy is for use of the land for the purpose of establishing the and running the industry, which has the potential of causing damage
that means to the
to,
surface of
to the surface, so far as the agricultural aspect is concerned. That is precisely your argument. For separate purposes, the levy is there. Okay. Oh, you want to rely on some judgment?
Yeah.
Which one?
that I have annexed in my written argument. as-
Tantram, which one?
Santiram Sharma is regarding
Not Santi,
Shantaram.
Sant.
Santaram
Not
Sharma.
Santi, not Asanti also. Sant.
Power of the state under one state. And second is my lord,
Oh, Santaram, which paragraph?
paragraph 7 and 8.
On what? 7 and 8 is what context?
On
Obviously?
the power of the state under 162 of the
162.
162, Article 162 of the Constitution. May I read the two paragraphs.
Yes. Yes, please.
We proceed to consider the next contention of Mr. N.C. Chatterjee that in the absence of any statutory rule governing promotion to selection grade posts, the government cannot issue administrative instructions, and such administrative instructions cannot impose any restrictions not found in the rules already framed. We are unable to accept this argument as such. It is true that there is no specific provision in the rules laying down the principle of promotion of junior or senior grade officers to selection grade posts. But that does not mean that till the statutory rules are framed in this behalf, the government cannot issue administrative instructions regarding the principles to be followed in promotion of the officers concerned to selection grade posts. It is true that government cannot amend or supersede statutory rules by administrative instructions. But if the rules are silent on any particular point, government can fill up the gaps and supplement the and issue instructions not inconsistent with the already. Then in paragraph 8, minor, in B. N. Nagarajan versus State of Mysore, was pointed out by this court that it is not obligatory under proviso to Article 309 of the Constitution to make rules of recruitment, etc., before a service can be constituted or a post created or filled. And secondly, the state government has executive power in relation to all matters with respect to which the legislature of the state has power to make laws. It follows from this that state government will have executive power in the respect of Schedule 7, List 2, Entry 41, State Public Service. In our case, it is Entry 24. And there is nothing in terms of Article 309 of the Constitution which abridges the power of the executive to act under Article 162 of the Constitution without help. That is first. And secondly, it's not a just family time. 2021 10 SCC 165. Infill hydropower and mangan. Paragraph 48 to 58. That royalty is not a tax on this point.
Yes.
Paragraph 48, 58, my lord. It
Please,
comes
let us see 48.
8. The sub, help you, lord.
48. Yes.
The submission on behalf of the appellant was
Read
that
49. 48 is okay. 49.
48 is 49.
49. Distinction.
The distinction between tax and fee was brought out by the constitution bench of this 14th so. Paragraph 9. The first question which calls for consideration is whether the levy imposed by the Immune Act amounts to a fee relatable to entity so. Before we deal with this question, it is necessary to consider the difference between the concept of tax and that of a fee. The neat and terse definition of tax, which has been given by Latham in Matthew verses so, is often cited as a classic on this subject. A tax, said Justice, is a compulsory exaction of money by public authority for public purposes enforceable by law and is not payment for services rendered. In bringing out the essential features of a tax, this definition also assists in distinguishing a tax from a fee. It is true that between a tax and a fee, there is no generic difference. But the compulsory exaction of money by public authorities,
Both are. Not but. Both are.
both are compulsory exaction of money by public authorities, but whereas a tax is imposed for public purposes and is not and need not be supported by any consideration of service rendered in return, a fee is levied essentially for services rendered, and as such there is an element of quid pro quo between the person who pays the fee and the public authority which imposes it. If
So what is
specific,
the quid pro quo? In your demand and payment, what is the quid pro quo? What services are you rendering?
the land of the state, after all, it's a land
No,
of
what is
state.
the service you are land is not of the state. It's their patta land.
Patta land,
It's
my
not government khas land.
that is
No,
true.
there has to be a quid pro quo. If you are trying to make out a distinction
Hmm.
between tax and fee or royalty.
Royal.
Tax, there is no question of a return service. In fee, in lieu of the fee, you give something in return. Like a license fee for applying a vehicle or any fee to open a shop. But tax is something else. Now, what is it you are giving them in return?
Might not be, ultimately, if the land belongs to the state for some particular lease, a person is given a patta for a particular land for particular period, but ultimately the state is the ultimate caretaker of the whole land.
So, Mr. Bhattacharya, there will be a vast difference between, see, pattas are also lease in nature, but a lease per se by the government may not mean a patta land. Suppose a government land, you give it, lease it out. That is pure lease for opening our brick clean industry. But their cases are that in their own patta land, they have set up brick clean. Now you are still entitled to levy something which you are trying to contend. The rules are there. Now, if you are trying to make out a difference between royalty and tax, then you have to make out a case that if it is royalty, we are giving them something in return. It's a quid pro quo,
Yes.
two-way. What is the quid pro quo?
Then we are allowing them set up.
That is not
industry.
service.
So it's a consensus between both parties.
That is not service. It has to be service.
We are allowing them
Fee for
to use
what?
the earth and damage the surface of that has bearing for the rest of the life of the earth.
That is a different argument altogether. We are
Right.
on the aspect of quid pro quo.
That is the only service that, so far as I understand,
Service what? Allowing them.
allowing them to use the earth.
That is not service.
And for that, there is a consensus between both parties, which culminated into there is an agreement between both parties that they will pay 10,000. And in that process, in the state writ proceeding, he was a part. And upon this closure of the writ proceeding, subsequent there to this impugn notification was that from henceforward we will levy 10,000 rupees as royalty per day.
Where is that order?
Last page of the writ. Page 76. 5th of June 2014.
76.
Sector P.
Mhm. Which one? The next one?
No, 1 to 5.
No, where is the order? In person, and the person.
Order of the High Court.
Yes.
Twen-
22,
29.
29. Yes. What is this? 29.
Annexure E.
Order dated 7/9.
7/9/2010. The only grievance of the petitioner is that the demand of rupees 25,000 per annum by way of royalty is not justified. The respondent,
Yes.
the respondents have filed an affidavit dated 4/9/2010. In the affidavit, respondents have stated the association of which the petitioner is a member has agreed to pay rupees 10,000 per year royalty instead of rupees 25,000 per year. Learned Additional Advocate General says that the matter is being considered and hopefully it will be decided in favor of the petitioner and their association. In the circumstances, the learned counsel for the petitioner does not press this writ petition and same is accordingly dismissed as no. So it is more of a consensus court.
And this royalty was not by forest,
No, this is by the
by revenue.
yes.
Yes, Mr.
Yes, I have already said,
The forest royalty it is not the subject matter of challenge.
forest royalty is not.
Then if you have consented to this, where
No,
do you,
no,
how do you
my
maintain
lord,
the
as I
challenge?
have already said, my lord, the sources of power, my lord, it is under that Mines and Mineral, my lord, the Act 90,
No, but this whatever 25,000 or 10,000, this was not under the Forest Act.
it was not under the forest.
Then
And in, my lord,
aren't you precluded from raising this challenge now?
my lord, the.
When you have
at this
consented
time-
before a division bench that you will be abide by 10,000,
Yes,
the 10,000 is the amount. There is no there is
But-
no enhancement.
but what?
So
what
where is
the-
your scope to make out a new case now?
my lord,
Or
it would-
rather, whether we writ court, a single judge, will have any scope of adjudicating a matter which has already reached finality by way of a consent.
My lord, this was not there because, my lord, the forest started realizing, my lord, the royalty only from the
For,
year
you
2020.
have not challenged forest demand.
No, because it is under the Act.
So that
And
is
madam-
it. So
and-
how can you fall back and again making a challenge which has already been disposed of by this court?
My lord, we are, my lord, why I am contending, my lord, we have already stated, my lord, the government has the power, state government has the power to, my lord,
Can you go into now?
well, change of law has come. My- Earlier, my lord, though law was there, my lord, it was not implemented and the royalty we are to pay. So
That-
whether the
that-
revenue.
That law is under a separate field by a separate department. There is no challenge to it.
Now we are challenging because at that time, my lord,
That they are not challenging. You are not challenging forest power, neither their source
No, no.
nor their action.
forest we cannot challenge because, my lord,
No, why you cannot challenge? You can may not be successful in challenging. You can
But-
challenge. It's not that you cannot challenge. Whether you can make out a case or not, it depends on the facts and
No, my lord, what
circumstances.
my submission will be, my lord, from the various provisions of the act, my lord, my lord, my lord,
There
applicable.
may not be any scope, Mr. Sakya. This aspect we are not. You read. Move that to another.
My lord, now here, my lord,
No,
whether,
it's very well settled.
no, my lord, now the,
Not on the merits, on the principles to be followed by a writ court. Dragon Rock case is very,
I'll.
Dragon Rock is very clear.
My contention is that the royalty, we are liable to pay royalty for the, my lord, is minor mineral. Now, instead of forest
No, Mr.
department.
Sakya, we are not on the merits, we are on the procedure to be adopted by us.
Yes.
By a writ court.
Yes.
Matters which have been dealt with, even if you have not urged that,
So this issue was never there, that both the.
that is deemed to have been considered and rejected, that is the law. Dragon Rock.
No, my lord, that is the, but then.
That
change
is the
of-
Supreme
change-
Court law, how can we
change
say
of
something
law-
else?
Change of law has taken place in
There
between.
is no change of law.
2013.
There is no, absolutely no change of law so far as the revenue department is concerned. Revenue 10,000 is continuing as 10,000. There is a consensus that 25,000 will be reduced to 10,000. We have agreed to it.
Well, the very sources of power they do not have, but why we did not tell, why
We
we,
are on a different footing.
well,
perhaps
why we did not challenge, it is because that, well,
Cannot have a case. Okay. We cannot. Please. Have you gone through Dragandra? I'm giving you the citation. Mr. Mishra? Jadon, yes. Central Bank. Yes, yes. This is AIR 2022 Supreme Court 3779. If you want SCC, I'm giving you the SCC 2022 8 SCC 378.
just my lord, to take up, I'll just take up this law and.
No, this is settled. You, Mr. Mishra, you bring it. You have the court's thing.
Tomorrow,
We are closing it. There is no scope.
or
There is no scope. You have a look at this. I'm passing on.
I have,
will,
Okay. But just note, mark the paragraphs.
no, my lord, I'll take up.
Okay. This may be easier for you to follow. Take the tab. You have to pay rent or royalty for use
Yes, sir, well, yeah.
on a per second basis.
In that case, may I have the, my
Per
lord,
second basis.
may I have the, my lord, this particular paragraph also, my lord,
We have not noted the paragraph. Yes, Mr. Gogoi, the paragraph have you noted?
but
We just remembered the name.
Yes. I heard it for the first time in this, when I
Okay.
researched and just regarding issues of res judicata.
yes, my lord,
Even points which have not been taken out.
Yes, but
It is deemed to be have taken and
Settled.
answered.
Yes.
That is what.
yes, that's what the res judicata. That, I think paragraph 11.
15 and 16. multiple proceedings cannot be initiated.
Because there may be a line of thinking that things which have not even been urged or
16.
points not taken, whether it'll be precluded from taking in a new, that has been answered.
Right.
Only to give a meaning to,
The principle of
the-
res judicata attracted where the matter in later proceeding have directly and substantially been issued in earlier proceeding between the same party in a competent forum having jurisdiction. Res judicata diverts the court from exercising jurisdiction to determine the lease. If it has attained finality between the parties, there is a distinction between res judicata and issue of estoppel. The case of issue estoppel, a party against whom a issue has been decided would be stopped from raising the same again.
no, not on that.
No,
We are on
not-
the,
Further held.
these are
to-
general principles.
But-
We are on a different point altogether. Points not taken or urged is deemed to have been taken and
This one-
rejected.
Further, where issue which could have been raised in earlier
Yes.
proceedings was not raised, principle of constructive res judicata would be expected to deny relief. Since multiple proceedings cannot be initiated in court in relation to the same.
Only on
cause of
this point.
So, here you are also fine, my lord. The issue of realizing, my lord, royalty,
No, which case law are you trying
my
to
lord,
refer?
two different sources.
Yeah, no, please, so the, cite the law.
But one is one is 1971 Supreme Court 2355. I'll just give you a hard copy.
No need, you can
No.
give the, I have already, you
Yes.
give it. I have requested the bar
But-
only to give the first page and those pages having those paragraphs. No need of wasting
Yes,
paper.
yes. My lord will come to paragraph 7 of that.
Give it, since you have made the copies, give it. We'll return it to you.
I'm sorry, my lord, is it extra copy of
Give us the citation,
1971 Supreme Court 2355.
1971?
Supreme Court 2355. And referring to paragraph
1971
7.
Supreme Court, AR 71, Supreme Court 2355. Name?
Mathura Prasad Sarju, that's what.
Paragraphs?
7.
7. What has been said?
Where the law is altered since the earlier decision will not operate as res judicata between the same. It is obvious that the matter in issue in a subsequent proceeding is not the same as in the previous proceeding because the law interpreted different.
Yes, yes.
But here there was no interpretation that notwithstanding the forest royalty, realization of forest royalty, the revenue authority is also, because at that time forest authority was not realizing, there's no law at that time. So now the law has come, Assam Mines and Mineral Concession Rules has come. Then, my lord, the notification of the my lord, central government has come that you have to get the environment clearance.
Hmm.
And thereafter only we are paying the this royalty to the forest department under the Assam Mines and Mineral Concession Rules.
Okay, yes.
So therefore, now royalty having been paid to the authority, in the name of royalty, again another department can it realize. That too without having any valid law. And here the sources of power that has been shown is the that assessment act that is only in respect of enhancement of the land revenue. And the notification what he is realizing, none of this notification on the brick clean, rather brick art used. And the notification, initial notification is of 1984.
So there is a distinction between use of the earth and utilization of the space. There are two concepts.
Right.
One is use of the earth, the material which is required to produce the bricks.
Right.
That is the use. The second is also use in generic term. But you are utilizing the space, the earth, to establish the industry, which has the potential to damage the agricultural aspect.
The notification specifically prohibits conversion of agricultural land into for the establishment of brick clean. One of the notifications
That we have seen.
that it is already there. And the government policy is to settle the government land for the purpose of brick clean. And therefore this levy of this royalty on 2.5, etc. This has come up.
Okay.
Not,
Yes,
not,
second one, which one? Which one?
not on this one. Then, my lord, year 2018 Supreme Court 3395.
Year 2000
18.
Supreme Court 23.
Supreme Court 3395. Canara Bank versus year 2018 Supreme Court 3395.
3395. Canara Bank.
Canara Bank.
Paragraph.
Paragraph 33. And subparagraph Roman small 3.
I'll just for my learned senior is saying that we are living after total, no man. Way back in 1994, there was some,
We will complete.
Yes.
We will just complete
Let's-
this.
So, my lord, that they have been realizing the royalty averment. First department.
Is 30.
33, my lord, paragraph 33, Roman 3. Another exception to this general rule flows from the matter in issue.
Three, 2, 3.
Page, it's down below 20, page 20.
33, 2, 3. There are 33, 2,
Roman.
and Roman 3. There is 2 also. Subpara 2, then subpara Roman 3.
Another exception.
Yes.
Another exception to this general rule flows from the matter in issue being an issue of law different from that in previous suit or proceeding. This can happen when the issue of law in the second suit or proceeding is based on different facts from the matter directly and substantially in issue in the first suit or proceeding. Equally, where the law is altered by a competent authority since the earlier decision, the matter in issue in this subsequent suit or proceeding is not the same as in the previous.
Yes.
But here, my lord, what the submission, my lord, I don't say that the law was not there for the forest department to realize. Law was there, but then they have not realized that it was realized through the revenue department. So we did not object because the sources of power traceable to somewhere. That state has the power to, my lord, levy royalty. So therefore, on that count, it was not challenged. Now, since 2013, when the this requirement of environment clearance came, it is specifically provided that we have to pay the royalty under the Assam Mines and Mineral route. Now the question has come when, my lord, whether in the name of royalty, my lord, demand can be made by two different sources. And second thing, my lord, they are trying to justify that this is an executive instruction or the executive order ruled from Article 162 for the purpose of, my lord, the executive order 162. But they have to, my lord, follow the rule of, my lord, that business, my lord. And under that, my lord, different departments are there for the purpose of different. My lord, they are trying to say that this is an industry, so they have, my lord, power to, my lord, issue the executive instruction, whether law exists or not. No doubt not this executive instruction or whatever it is only to, my lord, supplement. Now here also we'll see, my lord. Rule 4, the part 1, allocation and disposal of business.
Mr. Saikia, going to the merits will be difficult for us, for a single judge.
My question, this issue was whether, my lord, two sources, my lord, whether they can realize the royalty by two different departments.
No, when the division bench has passed the order, it will be difficult for us.
So that issue was not there. This particular issue was
For
not
that,
there.
for that, we have to overcome the first hurdle, which we are trying. We'll consider.
But-
We'll consider.
My lord, the question of res judicata estoppel, my lord, my submission is it may not come because sources of power they are under the Mines and Mineral Rules or the 1971 Act. So therefore,
Okay.
forest department is
Okay,
entitled
we'll
to.
consider, we'll consider. Mr. Gogoi, anything?
Well, I just to add, my lord, in 1994, my lord, there were rules in place because this
Yes.
traces back 1957 of Mines Act and MMDR. And at that time, 8%, 8 rupees was cubic meter. Now it has come to 20 rupees. What has happened, my lord? Perhaps, my lord, the word used both in cases is royalty. Perhaps if the revenue changes the word from royalty to the establishment fee, or that, then they have a different kind of case. Perhaps they petitioners confuse the use of the words because both words are royalty. And as far as record by the forest, my lord, it's regarding the consumable. If they're consuming, they have to give. It's not a fixed that this year they will consume 10,000, next year they will consume 1 lakh. This is not, that will keep on increasing or decreasing. But this royalty, which is on a challenge, is a fixed. Basically, it's a establishment kind of case, which we levy on the excise department, this case, man. That's all, man.
Okay. We'll reserve this. Conclude.
Obliged.
Anything? PCB was there. Where is PCB? Mr. Barua? Mr. Datta for anybody? And pollution control? No role, I think.
He just sets up the status of.
Okay. He's gone somewhere to remove pollution. Okay. The party, not a party. He was sitting here. Oh.
Okay.
The day we deliver the judgment, we'll return all this. You can use it in other cases also. No point wasting paper like this. And the other one, Mr. Saikya?
The next one, my lord, for the demand of my lord NOC, my lord, that we have
5824.
5824.
Demand of NOC means?
My lord, they said that for the purpose of sublisting the,
There is a cause of action alive or no?
my lord, this both are, my lord, because we said that since we comply all the, my lord, mandatory rules and regulation, the requirement of NOC is nowhere.
NOC by whom?
NOC from the deputy commission.
But isn't this a separate cause of action?
Yes,
What do you say on this?
my lord, that's what the same thing, my lord. We having been, my lord, complied all the factory license, industrial, whatever, labor abolition, whatever factor is there, my lord, we have everything. Notwithstanding that, they say that every year we have to obtain an NOC from the deputy commission. So we said that is without, my lord.
Yes, Mr.
power and-
Sharma, what do you say regarding the NOC? What about NOC from the Pollution Control Board?
Yes.
That you,
Everything, man. And in fact, the interim order was that if we have all the my lord, these documents, and then in that case, we will be allowed to run. So therefore, NOC has not been. Order of- So this is an order of 14/11/24.
now why is the requirement of NOC there, Mr. Sharma? By the Deputy Commissioner?
But get it. One, very and included. There was a set of facts. In terms of that.
No, so far as your revenue department's arguments is concerned, relating your power to some the entry in the part 2 list, those we'll consider. But so the role of the deputy commissioner insisting for an NOC, irrespective of the fact that the petitioners are abiding by all other requirements in law. This as a additional measure you can take, but it has to be relatable to some source. NOC under what provision? And they are existing brick industry. It's not new brick industry. How have you justified? You want to have some supervision kind of a thing or what?
Yeah, deputy.
Yes.
Annexure A is the source of power.
Source is what? If you cannot point out the source,
Cannot.
then
Source is not there, only a title.
then we may have to make the interim order absolute. The other requirement, if they are following, there may not be any requirement for further NOC by the Deputy Commissioner's office, unless you show that this is because of this purpose. Okay. Next word. Yes, next. Board नाम लिखिए हाँ विजय से क्या RS Mishra
Something item number 7, but the hearing matter also. That for a particular
আজি তো এটা বজাত উঠিব লাগিব না Okay, we will have some other day. We'll have some other day. We'll have to rise today early, I think, 1 o'clock. Yes. Mr. Nath, you are here? No, we saw him just now somewhere. He was in the court, I think. Red petitioner? Mr. Roy Chaudhary? Time being? Who was with Mr. Roy Chaudhary? M. Hussain or somebody was there.
M finished.
What is this?
The interlocutory application we have sought for modification of the order. It is 4/3/2024. That order
Code 324.
4/3/24.
Interim order.
Interim. At page 16, the order is there. Lordship in the interim has directed that the petitioner shall not be evicted from their land, which is located at Peltoli Daily Bazaar under Agorijan Ancholik Panchayat till the next reasonable date. That order is still open. Kindly, if Lordship picking up the matter, kindly come to paragraph 3.
Sir, where is the petitioner? Red petitioner? Page?
Page 7. This is the projection made by them.
Page 7, paragraph 3.
Page 7, paragraph 3. This is the projection made by the writ petitioner. And our case is at paragraph number 5. If the
Please read 3. Let us understand their case.
Yes, the basic ground taken in the writ petition that the scheme proposed under PMGSY, being PMGSY package number AS 19791 MRL so Rupohigaon Uttor Etapara to Uttor Herapatti via Laogao is totally misleading, as Laogao village is situated in eastern side of Uttor Etapara and Uttor Herapatti is situated in western side of Uttor Etapara. It is alleged that the construction of one RCC bridge has been sanctioned over the aforesaid bridge, which is imaginary, as there is no river or low-lying area over the said road. And in the name of the construction of approach road to RCC bridge, the concerned authority has decided to evict the petitioners and other institutions at Beltuli Bazar. This honorable court, after hearing the matter at motion stage, was pleased to issue notice to all the respondents by order dated 4/3/24. And in the interim, it is directed that the petitioners shall not be evicted from their land, which is located at Beltoli Daily Bazar under Khagorijan Anchalik Panchayat till the next return. So the paragraph 5 we have stated, in fact, that projection is not correct according to us, because the actual fact of the case is that the road, namely MRL Rupohigaon Uttor Etapara to Uttor Herapatti via Laogao, is a PMGSY major rural link, comprises segment of 6 different rural roads and connect directly or indirectly 24 numbers of habitation. The road alignment is as per online management monitoring and accounting system portal of NRRDA, and as per section BPR found to be started from Beloguri Hatipara pass through Laogao at Beltoli Bazar, existing wooden bridge, and end at Uttar Herapatti. The alignment was generated and availed in OMMAS portal of PMGSY for Khagorijan block trace map approved by the Honorable MP Nagaon on 5/12/2021. The GPS photographs taken during preparation of the DPR established that the road alignment passes through the existing timber bridge at Beltoli Bazar. The state timber bridge is at Beltoli Bazar over the river Sonai, and proposed RCC bridge section at the same location, and hence the bridge proposed was done after proper survey.
There is already a timber bridge,
There is a timber
which you want to replace by an RCC bridge.
that is to be
And in this construction,
logic.
the petitioner is thought to be affected. He
Yes.
says that there is no river or low-lying land.
In fact, they said that this particular bridge is not within our scheme. In fact, they have filed a reply to our IA. In that reply also they have said, but I have the photograph of the bridge and I'll place it. But that is what they are disputing. Kindly take up their reply to our. One vital aspect is there in the IA. I'll take a lot, but the reply of the petitioner, they said that the paragraph number 5 of their reply, last sentence, the scheme is page number 38, relevant is 30. They said that the last sentence, scheme is paragraph 5 of their reply, last sentence. They said that the scheme is itself in respect of another area, and as such interim order allowing the writ petitioners to continue their petition at Beltoli Bazar will not affect the communication of the area. Then
Yes.
paragraph number 7. We said that they said that the construction of the proposed RCCP is physically possible to include in the scheme, that is MRL so and so. On the other hand, writ petitioners have placed several documents that under the scheme RCC bridge at Beltoli Bazar is not in. That is what their case is.
and paragraph 4, page 37, they said. Page 37, paragraph 4.
30?
Page 37, paragraph of their report. The applicant deponent begs to state that it is on record that that Laogaon village is situated in eastern side of Uttor Etapara and Uttor Herapati is situated in western side of Uttor Etapara. As per scheme of the road starts from Uttor Etapara and ends at Uttor Herapati, but the state road cannot be made through Laogaon. Under the opposite scheme, the road alignment cannot be started from Beloguri Hatipara and ends at Uttor Herapati. The trace map of Phagorizan block prepared under Public Works Department clearly indicates that Beltoli, Laogaon, Beltoli, Bajar are situated in eastern side of Uttor Etapara and Uttor Herapati. The instant scheme has no connection with the scheme of road started from Uttor Etapara to Uttor Herapati. The GPS photograph taken at the time of DPR is totally incorrect and no proper inquiry was made at the time of sanction of RCC bridge at Beltoli. That is what they replied. But what I have said was that as per that scheme, the photographs I have given, the wooden bridge is shown, and at one side of the wooden bridge, some construction of. In fact, although in this petition, 3 petitioners are there. Actually, there are 2 petitions. Petitioner number 1 and petitioner number 2 and 3 are. The 3 is the wife of petitioner 4. So these 2 petitioners, in my verbal submission, they are occupying this particular place where the construction is. And in our IA, we have said that the no notice has been issued. They are occupying that place. And in paragraph 7, we have said that till date neither issued any notice nor given any information for eviction to the present petitioner. As such, the petition itself is privileged.
But how do you construct the bridge without giving a notice for eviction?
They have to be evicted, and for that, ultimately from the district authority notices will go to them, and what they have projected before the honorable court that particular bridge doesn't come under this particular. We have already the respondent.
No,
has already
Mr.
engaged.
Nath,
Mal.
we may not be too much interested with whether a bridge is under a scheme or not. The construction of the bridge, there is no doubt that it is for public interest.
It is for public.
Now, irrespective of the fact that it is a part of the scheme, not a part of the scheme, we want to know that whether there is a valid project for construction of a bridge in the area where the establishment of the petitioners are there.
There.
They are trying to contend two contentions.
Okay.
This bridge is not of the part of the scheme. We may not be very interested in
That is-
accepting that.
that's
But the more important part is that without there being a necessity for a bridge, where there is no river, no low-lying land, you are making an imaginary projection of a bridge which will affect his establishment. On that, we are more interested.
that is what their case.
Yes.
Our case is that there is a wooden bridge, and by the side of the wooden bridge photograph I have taken, some places are there.
No,
Ultimately,
Mr. Nath, please correlate
Yes.
the photographs with longitude and latitude
yes,
with your averments that this RCC bridge which you are contemplating or which you are planning to construct is on the same site. Where have you stated?
the note is there, and the red circle marks are there. Those are the 2 shops. Kindly see at one side of the bridge, it is in the government land, and we have stated.
No, you're not on that. We want to know from you
Yes,
in the IA,
Note
where have you stated that it is the same site where the timber bridge is now existing? You want to replace it by a RCC bridge?
the top below note is there. Rupohihat, Uttor Etapara to Uttor Herapati via Laogaon.
This is the same area, same site.
This is the same. This is the GPS location. GPS location and the photograph of the bridge.
Okay. Yes, Mr. Barbia.
Yeah.
We cannot wait indefinitely. We have accommodated you since 10:30. Now we are at, then we have heard. We are closing this.
And one.
It cannot be to your convenience. You need to be here when the matter is called upon. We accommodate you from 10:30 to 12 o'clock. More than that, we cannot. More than that, we cannot. Matter was adjourned on an earlier occasion on your behalf. They have, it-
Page number
we'll close this. We'll close this.
page 35, it get clear.
Order was passed on the motion stage, almost ex parte. They were without instructions. Now they have come up with instructions. Projection does not appear to be fairly done. Factual misrepresentation, suppression. Those perhaps we will not tolerate. What last chance? We are giving chance from 10:30 to 12:10 to 12:10 now. This is not important for you. You have more important works to do. Do those important works. This is important for them. We have accommodated you. It's not that we have not accommodated. Last occasion we have adjourned this matter. Yes, we're closing this. Anything else?
Look, page number 35, the repeat, it is a annexure 7 of the repetition. It itself
30?
35 of the repetition, annexure 7.
You've met.
No, this is the executive engineer communication to the circle officer, right of way. Has got
30
right of way
of the writ petition.
of the repeat.
35.
Yes, annexure 7. Just to show that there is a existing SPT footbridge and that has to be replaced. With reference to the subject cited above, I have the honor to
What is SPT?
the tall pine tree or tall pine tree wood bridge. Wood. I have the honor to state that the RCC bridge is sanctioned under PNPSY package number 2 and 2 MLM. This is the same project, Lord. Replacing the existing SPT foot bridge now for foot execution of the proposed RCC bridge. The status of right of way is required in both sides of the existing SPT bridge at Beltoli Bazaar.
Okay. That's all?
Look, that's all. And
Mr. Roy Chaudhary, we have waited for you since 10:30.
My lord,
And again, your colleague was making an adjournment. We cannot do
my
an
lord, I'm
adjournment.
extremely sorry.
If this matter is important for you, you should be here.
My lord,
There's an expert almost interim order.
my lord, what I'm extremely going to my head down. My lord, I was on leg, my lord. Came ready. Just not only thing, my lord, my submission before your
Okay,
lordship.
well, have a seat for 2 minutes. He's completing.
but in paragraph, I'm taking back your lordship to the IA, my lord. Paragraph 7, we have said that they have what protection they have said is not correct, and we have also said that till date neither issued any notice or nor given any information for eviction to the present petitioners as such the instant petition is premature and the same cannot be entertained as no right of the petitioner has been violated as on today. But they are occupying some land and they are encroaching the land and it is known to us, but ultimately the procedure will be followed and they will be given notice and all these things. But now by disputing that the bridge doesn't cover within that scheme, they have obtained the order.
Where is
And-
the interim order?
Interim
Which-
order at page number 16.
1/6.
Once,
Please read the interim order.
yes. Hart so and so issue notice to the respondent returnable after 4 weeks. Ms. MS S. Sharma, learned government advocate, accept notice on behalf of the respondent. number
Leave
three.
those
Lord.
in the interim.
Insofar as the Now,
Interim.
in the interim, it is directed that the petitioner shall not be evicted from their land, which is located at Beltoli Daily Bazaar, under Khagorijan Anchalik Panchayat till the next date or till the next returnable date. Pendency of the writ petition shall not be a bar for the executive engineer to submit report to the deputy commissioner, which has been sought on the application dated 4/1/2024 submitted by the petitioner. So that is the report I have indicated. Kindly, I have the copy.
Was this interim order extended?
No, it was,
Last occasion means in the writ petition.
my lord, your lordship extended it. When my lord, the NARC was not there, so there's not time.
But in the writ petition, the 4/3/2024 was made returnable by 4 weeks. Interim order was till the returnable date. Thereafter, the matter did not come up.
Yes,
But it's a very kind of a conditional order. See, they have very fairly submitted that even notices are yet to be issued to you. Oh, don't you think it's a premature thing? He has made a statement, we record his
my
statement.
submission only, your lord.
Yes.
Private interest cannot go above public interest. There is a public interest, there should be a breach.
Yes.
This is a disputed question of fact, writ petition will not enter. My lord, whether it is on the lagoon is in the, our bazaar is on the eastern side or western side, that also I will not try to place it before your lord. My lord, as regards premature, my only submission, AR 2002 Supreme Court page 790, while deciding the point of res judicata, has said apprehension of bias can and subsequent real biasness, there can be two different writ petitions. So,
We are not even deciding something on bias. Why are you going on
not
bias?
bias. I am on the ratio of that writ petition where it has said that apprehension also a writ petition can be.
No, those we are not disputing, but where is the cause of action?
Cause of action, my lord,
Without a
they
notice,
have admitted by
no, without a notice, can you be evicted?
no, my lord, as per
Then-
the Salakuddin, only thing is this.
When
my
the
lord,
notice comes, come before this court
Well,
will
let-
decide.
let them give a issue. Your lordship may give it a direction that as per after Salakuddin, they
Why
have
should we give a direction? It has come from, it has fallen from the senior ground advocate. He has said not even notice has been issued.
my lord, they have stated.
But
that
your
you will be
projection-
evicted.
But
They
your
said-
projection that the bridge is not a part of the scheme appears to be a wrong projection.
My lord,
And even if you assume that it is a right
my
projection,
lord,
how can you restrict the construction of a bridge
well, but
by making an averment that there is no low-lying land and no water, no
my only
water body?
submission before your lordship is this. Now, my lord, there was an inquiry to be held. Now, I don't know whether the inquiry has come. Because there was an inquiry going on whether the bazaar area where the bazaar is situated, whether that falls within the beach zone where it has to be constructed. We have a big chart of the, my lord, through photograph of all this, but I will not go to this. Put it. My submission, my lord.
No, Mr. Roy Chaudhary will grant you the protection that without due process of law, nothing can be
My lord,
done.
that much, my lord.
That-
My lord, that much, I am not asking for any blanket stay, but I am asking that after Salakuddin, because if it is a roadside land also, Rule 23 says, as per Rule
Okay,
18.
okay. What about the writ petition? Should we dispose of the writ petition?
Yes, your lordship will dispose of.
Okay, writ petition will dispose of.
Well, your lordship will dispose of with the direction that notice has to be given and on the. basis of a
Obviously,
notice.
without notice, how can it be
And my
done?
lord, because after this.
How can it be done? How can it be done without a notice? Okay, well, and yes, you're for, what is your name? Name? PK?
My only,
For R10? You are also one of the applicant in the second IA?
Yes.
For vacating?
Yes,
You are made party by name?
yes,
Why?
KK engineers, they are the person who have the work has been allotted to them.
Okay, you are the contractor.
Well, since Joseph is
Okay,
taking up
okay,
the-
complete code, very good. Okay.
I have one submission in the writ petition. Well, in the writ petition, they have the prayer that mandamus shall not, in the nature of mandamus should not be issued, directing the respondent to stay the proposed eviction at Beltuli Bazaar under Nagaon Sadar Circle in Nagaon district till inquiry is completed by the respondent number 3. So the District Development Committee which was initiated in the representation at Annexure 4. I'm just indicating the annexure, the representation of the petition, and the page number 35 annexure 7 I have already indicated. Their basic dispute in this case is that that particular bridge doesn't come here. And in fact, from the representation lot you will see, they have made prayer that we should page number 36
Of the writ petition,
of the writ petition.
yes.
Subject is prayer for shifting the proposed construction of RCC bridge over Subri River at Beltoli Bazar. With due respect, it is stated that as per our instruction, the construction of RCC bridge has been sanctioned near Beltoli Bazar, along with the road proposed to be constructed towards Therapati via Puento. If the proposed RCC bridge is constructed at a place of present wood bridge, the Beltoli Markaz Masjid and Beltoli Bazar will be badly affected. Therefore, if the RCC bridge is constructed 100 feet towards eastern side without affecting the masjid, none will be affected. My respectful submission is there is a wooden bridge, it is admitted. They have requested that it should be the proposed new bridge should be shifted to some other. So they cannot, their projection that there is no bridge proposed in the RCC bridge proposed in the scheme. That itself is not correct. There is a bridge in the scheme. They know. They have requested. Therefore, ultimately, the clarification has come on page 35. I have indicated. The executive engineer has got the right of way from the circular.
Yes, okay.
My lordship permits me only one. My lord, because your lordship has already, I have made my submission that public interest will definitely go above my private. Let there be a construction if they want to evict me, because in their IA they have said they will evict me. My lord, in the IA, my lord, I take your lordship to the IA.
Yes.
That IA filed by the private respondent.
Yes,
Respondent number 4 is that my lord, private respondent in their affidavit they have stated that in paragraph I'm pressing. My lord, page 11 they have said.
now we have, we'll take care of that.
Well, only thing is that
Eviction has to be done if at all by following the due process of law, not like that.
and only another pair, my lord, on a notice given, my lord, I had the right to give my representation on the ground of a bona fide right.
Those, why should we make those? They are wise enough. We will not educate them. If you,
Following
if you,
Only by issuing.
why should we give the guidelines? Let them make a mistake, you come to the court
My
again.
lord,
following the due process of law.
Okay, Harry Kori. Dinath. Subornam likhido. And dispose of court. Save a court. Save a court. For delivery of orders by an court.
obliged.
Okay.
I'm obliged.
We'll dispose of both, all the things.
Yes, sir.
Both the IAs and one writ
My
petition.
lord, I am again sorry before
No,
lord,
no.
my lord. I was,
Okay.
I
Okay.
was, my lord, in some other court. My lord.
You're not giving importance to your matters.
No, my lord, I actually, my lord, my lord, my lord. I was running, my lord.
You
my
have put your friend in a distress.
lord, my lord. I am sorry.
Okay, next.
Obliged.
Here for whom? Panchayat is there. Harry, S. Datta, Panchayat. S. Datta.
All the officials have been made
Yeah.
party and
Let's see.
ultimately one year, more than 1 year.
Ginath. P.K. Basu. S. Datta. Okay. Mr. Madam Gayan is also for TGC. Oh. A. Gayan. TGC.
P2 I'm a bit.
No, we'll say official respondents, state
Look,
respondents. Okay.
Obliged.
Yes, next.
6 and 7.
May it please the Lord. My lord, I tender my apologies. I was on lag actually.
Which matter?
On 6 and 7, my lord. It was 12 in the morning. I'm tendering my apology. I was not able to attend. My lord, here,
Yes, 6 and 7.
yes. My lord, may kindly take up item number 6.
What are these matters?
My lord, in short, if I may submit, my lord, these two matters basically pertains to, my lord, a notice which was issued by the Archaeological Survey of India in the year 2015, saying that my residential premises, my lord, wherein I'm staying on my own Potta land, my lord, some construction was there in the first floor, and that construction was unauthorized, and mostly that this house of mine basically falls within the prohibited area or zone of an ancient monument called Devidol in Orihagar in the district of Sibsagar, my lord. Now, this issue pertaining to whether my house falls within the periphery of this protected monument or outside has been long decided by this honorable court, where my father had moved this court on the same ground in the year 1991 and 1992, where this court had observed. May I, my lord?
Yes.
Yeah. So wherein
It was
this-
decided.
yeah, it was decided by this court. I have the order, and by that order, the court has observed that this land falls outside the protected area. And
Now, then why is there a new fresh cause of action?
yes, the problem is periodically they keep on issuing me stereotype this kind of notices that
Madam,
this is the bone of contention, my lord. And before
if it was decided, unless you pray for review or go for an
yeah,
appeal.
1991 case, my lord, 91 case.
1990, my lord, but that is there, but 1992, my lord. That is the notice.
I'll come to that point. He's trying to deviate from the main issue, my lord. Just let me, my lord.
No, what was the dispute, the issue
My lord,
in the
court-
matter which was espoused by your father?
Yes, ma'am. My father, when he came before this court, was that this land falls within this zone, and therefore the settlement, the potta which was granted to me, was cancelled by deed and minister at the behest of some minister, and the state government had cancelled my potta, my lord. Then I came to this court. Now the court, after seeing and my lord recording the submission and materials placed on record.
No, the consideration by the court
Yes, my lord.
on the earlier occasion, was it on the aspect
Yes, yes.
that the archaeological site was being
Yes,
affected?
because objections was raised by people residing close to my house that potta should not be given because it falls within the prohibited zone. So they did not come. It is a fact, because my potta was cancelled on the complaint made by some individuals that my land falls within the prohibited zone. They ought to have notified my land. My lord, this case was heard at quite a length by Honorable Justice, my lord, was retired, my lord. And that order, this court has clearly indicated and have directed them that you produce the notification which basically says that my land falls in this prohibited zone, because there is a mandate of the law under the Archaeological Survey of India Act that before you declare a land, you should notify to the person concerned that you show that this land falls in this prohibited zone. And when was this notification published? You bring it on record before this court. They have failed miserably till now. This order was passed to back, if I may take a lordship, on 13/9/2022. If a lordship comes to that order, 13/9/2022. Just quickly, I'll read this order, madam. This is very important to come to the straight away to the point.
13/9.
13th September 2022, madam.
Yes.
My lord, may I just read? I'll take some time, my lord. Just reading this order is very important. A notice dated 23/8/2011 was issued by the Superintendent Archaeological Survey of India in the office of the so-and-so under Guwahati Circle under Rule 38 of the Ancient Monument Archaeological Site remained 1959. The first paragraph of the notice provides that petitioner had undertaken unauthorized construction near the centrally protected monument of Devidol at Gorisagar, Sibsagar, within the prohibited area of centrally protected monument, which according to the superintendent archaeologist is in contravention of Rule 33 of the Rules of 1959. Rule 33 of the Rules of 1959 provides that no person other than an archaeological officer shall undertake any mining operations for any constructions in the prohibited area. Prohibited area is to be declared. This is important. Prohibited area is to be declared under Rule 32 of the Rules of 1959 by following the procedure of issuing a notice under Rule 31, which involves the process of no objection being raised. In other words, in order to constitute that a particular area is considered as prohibited area, there has to be a declaration by notification in the official gazette that the concerned area is a prohibited area. Now, paragraph number 3, my lord. In order to appreciate the first paragraph of the show cause notice dated 23/8/2011, there is a requirement to have the information as to which notification published in the official gazette the land of the petitioner was declared as prohibited area, and whether in doing so the procedure under Rule 31 was followed. Secondly, my lord, the second paragraph refers to central government notification number 16/6/1992, by which any area up to 100 meters from the protected monument limit and up to 200 meters near or adjoining a protected monument to be protected and regulated area both for the purpose of mining operations and construction. The said notification be also produced before this honorable court on the next day. The third paragraph of this notice dated 23/8/2011 requires the petitioner to show cause as to why he should not be punished with the imprisonment which was extended 2 years. My lord. His part is regarding punishment. Now, fundamental issue is, my lord, as indicated in this order under paragraph number 3. They will have to produce, affidavit has been filed, no such notification they have produced or have been able to show that my land falls under this area. And my lord, this is the core issue before your lordship, my lord, to decide. If they can show that my land in the year 1992, whatever my learned friend is referring to, was already given it to me, and the order of this honorable court is wrong, my lord, then, my lord, they will have to take a different, my lord, step, because they will be contradicting, my lord, two things coming into being, my lord. One, this court order, and then notification, my lord. Let's
Yes,
just read the order of this honorable court of the year 1990, my lord. If my lord may kindly come at page number 34 of my report.
yes.
My lord, the petitioner Betharam Boiragi is the petitioner in the other retreat. So he and this current petitioner has filed this case jointly. So anyway, my lord, I'll just come to this the first part of this court judgment, my lord. By this writ petition under Article 226 Constitution, the petitioner Betharam Boiragi and Sri Rameswar Hazarika, father of the current petitioner, has assailed an order dated 27/10/1979 issued by the Undersecretary to Government of Assam, by letter dated cancelling the settlement of the land given to the petitioner on 11/9/1979, and also order dated 2/9/1983 of the Revenue Minister, Government of Assam, communicated so and so on Iman Tariq, so in 1983, upholding the cancellation of the settlement given in favor of the petitioner on 11/9/1979. Thereafter, my lord, may kindly come. Both the petitioner are living in Pukonpetia village, Gorisaka, for many years. Petitioner number 1 has been living and possessing the area measuring my lord, 1 bigha of land under Dag number so and so since 1950. So lordship can skip this part. This is the background. Then kindly lordship may come to paragraph number 5, my lord, at page 36.
Hmm.
The respondents have responded. The respondent number 1, State of Assam, and respondent number 2, Deputy Commissioner, did not file an affidavit of opposition nor contested the contentions and allegations of petitioner in the petition. Learned advocate so and so. Original records were brought before this court, my lord. Then lordship may kindly come to page number 37, paragraph number 6, the last part of this paragraph, my lord, I'll just read. It was stated, have my lord firm, it was stated that answering respondent filed petition for cancelling the settlement order in view to protect the historical monuments. Have lordship found
Yes.
at page 37?
Now, finally, what was said? Let us come to the.
Yes, finally, my lord, kindly come to the.
Is it allowed?
Yes, my lord.
Washed. Or have you done an exercise under the
No.
requirement?
And put. And there is a sheet, but where is that of the complaint, but yeah. 144 dated yeah, part 26 subject dated 29. Central government gave 1 month notice of its intention that the area up from the protected and further beyond up 100 that monument proceeded respectively for the part both mining but construction.
Have you given notice?
Yes,
Where?
notice that is by the notification yes,
No, where is the notice?
I don't that
That is the requirement.
Is it requirement? Of course, my lord.
Where is
Where is
the
the
where
notice?
is the notice?
Where is the notice?
Because notice will have to specify that his premises is within 100
Within the protected
meters.
area.
Without that, where is that exercise?
Definitely.
now they are
Now, where is the determination that the premises of the petitioner would fall within this 100 meter?
That is beyond 100 meter and 200 meter the protected area, and that is the
That is the requirement, my lord.
protected that there in that case number 84.
No, there is no dispute with this proposition.
Yes.
But that his premises is located within the specified area. Where is it? From where do you get?
My lord, they also admitted in case number, my lord,
My lord, may I kindly come to my
Yes,
order
ma'am.
at page 48, where it is a court has observed that my land is far away from this protected
Yes,
area.
my lord, that order is 1990, my lord. His order is, my lord, referring the order.
This order which my lord is reading,
1990, my lord,
Yes.
and notification came on 92,
maybe.
100 meter and 100 meter. And that order is the judgment for settlement of,
We are not on the judgment, madam. You just show us the material from which you can conclusively hold that the premises is within the restricted area. From where? Which document? Then if tomorrow you say that my house is within the 100 meter,
Oh, my lord.
then why no?
that
Where is
is-
the notification?
is-
My-
You have to give a notice. There has to be a fact-finding thing. We are not doubting about that notification.
Yes.
But where is the fact, where is the notice that his or her house is within that specified? It has to be within that area.
that is that the documents regarding this is 1990.
We are not on the applicability. It may apply, but where have you applied your mind that this notification applies to the premises? If anybody has a house in Sipsagar, everything will come under this.
Yes, my
No,
lord.
that is under 100 and 200.
Show us from where. Where did you do the exercise? That it is this is within 100 meters. This is within 200 meters. Where is the finding in the
Order, my lord. Yes,
Division
my lord.
bench
Kindly
judgment?
lordship may come to
page?
page 40, my lord, 3, paragraph number 13. If I may just read my.
Yes.
The grounds stated by the government in their order dated 2/9/1983 were untenable and unreasonable because action of destruction, my lord, defacement, and ultimate ruin of the historical monument Gorisagar, Davidol, and Bisnudol had not arisen for the reasons that the dark number, my dark, and dark number such and such stood far away from the bank of Gorisagar tank and outside the area of the, my lord, Davidol and Bisnudol. This has not been challenged. Into 1992, is assuming they have this, they should have come with a proper application. Why they have not come?
That is
What
that's not for construction.
My land is within.
Settlement. And that is 1990 and this 100 1992 method. I have seen my lord the record of my lord is whether his area will come under that.
That is what we are. Otherwise, there is nothing else to be decided.
Yes, my lord.
We may not dispute with the proposition that a law of 1992 may have application. It might have application.
My lord, my lord.
But to make it applicable also, you actually have to make out a case that the premises is within the restricted zone.
Correct.
Notification's existence is not in dispute. What is in dispute is the application of the notification so far as the premises of petitioner is concerned. What have you stated in your affidavit? What exercise have you done?
None.
This is pending since so long.
Yes, my lord.
Yeah,
And
my
this is the only issue court has been my lord, directing the authorities to bring the records and show before the
Where
court.
is your affidavit, madam?
Start from page number 4 mile.
74.
Sorry, 7.
What have you stated?
Stated stated in case number 81, paragraph 6.
81. Please read.
458 that as per provision of Act of applied for the purpose for construction, there is a complete ban on any construction in any prohibited area in that is 100 meter from the boundary of the centrally protected site. Also, it stated
Where have you stated that it is within 100 meters?
My lord, the paragraph number 2, if your lordship sees, there is a statement made. However, they are basically not saying what they are actually saying now. Ma'am. They are saying in the affidavit that their boundary wall is close to my house. Now the act says that it has to be from the protected monument, not from the boundary wall. So this is the new construction of words they have used here in paragraph number 2, my lord. The land of the petitioner stands 2 meters from the notified boundary of the centrally protected monument. Or the boundary, for the first time, they have made it from their own understanding of the act. In 1996, a notification dated such and such was issued under the provisions of section so and so setting out 100 meters limit from the notified boundaries. It was never from the boundary, my lord. It was from the protected monument. Because to demarcate a boundary, obviously, my lord, a lot of people's houses will be, my lord, demolished in due course in that case.
and type there at case number 56 in reply to our notice, my lord.
56.
Yes, case number 56.
Yes.
And it is replied to our earlier we had to notice also.
Hmm.
I have gone through the content of the letter under reference from 13/5/2000 and I'd like to inform you that fast food construction over the old residential building is going on. The permanent construction of our residential building had been started in 1990 after the judgment of Honorable Guwahati High Court Assam 2719 in favor of us. In the judgment, the respondent was directed to keep the settlement of the plot of land which was in our possession with dwelling house since 1990. Situation on the bank of Jamuna under Dark number 133, which is outside the area of Devi Road. The construction of our residential building as per our requirement could not be completed in the time. So the present construction has been started just to meet our family requirement. I would like to bring your kind notice of to the following construction around the hospital and hospital completed in the recent past. That is another part. In here, that is for another person, that in view of so many constructions were made within the prohibited area 100 meter as mentioned around the Tibodol and Visnudal and Gorisa. Our construction of transport to meet our family requirement dwelling site for which was granted giving due consideration of the preservation of ancient moment by the Guwahati High Court. Assam could not unauthorized construction.
On my own portal, and I am constructing. Where is their
That
notification?
is his own portal and that as per the code of the settlement.
Yes, of course.
But that is some beyond the, I'll bring that record, that his
You
land.
bring that, you bring
Yes.
that record, you bring that record. Third Sri H. Boragohe, learned counsel for the petitioners. Para. Also, also heard Ms. A. Gayan, learned CGC. Full stop. Ms. Gayan, the learned counsel. And while Sri Boragohe, the learned counsel for the petitioners, has relied upon a judgment dated 2/7/1990 of this court passed in Civil Rule 939 of 1983, comma, the learned CGC has submitted that the judgment may not have an application inasmuch as subsequent to the said judgment, a gazette notification has been issued putting certain restrictions of constructions within a specified distance from the protected monument. Full stop. Para. On the prayer of Ms. Gayan, comma, the matter is adjourned by 2 weeks to enable her to produce before this court the relevant records wherein an assessment has been made that the construction in question is within the prohibited distance as per the Gazette notification. Yes.
I'm highly obliged.
2 weeks
Madam-
we are granting. Old matter, please bring it.
My lord, the second case, similar order will follow. My lord.
Same order.
I'm highly obliged.
Item 9.
9.
May it please the court. Affidavit in opposition was filed recently by the opposite party. But if we need some time to file about,
Okay. On a prayer made on behalf of the petitioner, matter is adjourned by 2 weeks to enable filing of rejoinder affidavit.
Item 10.
Kindly matter may be adjourned for the day on unless counsel Tessie Gogoi is out of. I'm not in this case.
I'm for a private respondent.
On a request made on behalf of the petitioner, matter is adjourned to be called after a week.
Interim order that only.
Interim order passed earlier to continue till the next date of listening. So we put a date. Where is the interim order on the last date? There is no interim order. Interim, next date already. List on, on a request made on behalf of the petitioner, matter is adjourned. Para, as this matter is of the year 2018, list on 24th, next Thursday, 24th, interim order, if any, stands extended till the next date of listing.